Welcome, everyone. My name is Fawaz Baum, the DFW Muslim Bar Association president. Thank you for joining us this afternoon for a discussion on a very important topic regarding franchise law and franchise agreements. Just a little quick blurb about the DFW MBA. A lot of us are familiar, obviously, with the MBA and have participated in so many programs. We, as a board, are happy to put on these CLEs to educate our members, but also to highlight the amazing diversity of our membership in different practice areas. They're experts in their own right. And this, hopefully, inshallah, will help us get educated on not only different topics, but also try to identify, who are the experts in our communities that are really doing cutting edge work. We've done a CLE on the Corporate Transparency Act. Last week, we did a CLE on Islamic wills and trusts, which was very, very popular. There were a lot of questions, and it was wonderful to see. Just to plug in a couple of events going on this Saturday, we are going to be at the Oak Cliff Empowerment Center. They're having a celebratory event to recognize yet another anniversary of them being participants in the Oak Cliff community and helping the Muslims in that community. You'll recall we've done drives, we've done iftars, we've done other meaningful ways of contributing to that community in particular that often gets forgotten. So inshallah, if you are around in Dallas, it's a little south of Dallas in Oak Cliff, but a wonderful opportunity to connect. It's at 6:30 on Saturday. There are more details on the DFW MBA website. We'll also have another Coffee and Connections coming up in October. Details haven't been announced yet, but just look out for that. And then just making a last plug for the NAML conference, which is the National Conference of Muslim Lawyers that happens every year. This year it's on October 31st to November 1st in Irvine, California, Southern California. So please definitely try to make it out to that one. We always have an incredible showing of lawyers, but also lawyers from Dallas that attend, and it's always heartening to see on the national scale what our lawyers are doing. So just wanted to lay those out very quickly. I'll give Farheen Ibrahim a really quick introduction. She deserves a really long one, but we'll keep it short. Farheen Ibrahim is currently an in-house attorney at Unleashed Brands, a youth enrichment platform that franchises 8 brands, including Urban Air, Adventure Park, Siblin, and The Little Gym. In her role as corporate counsel and a member of the senior leadership team, she oversees franchise compliance and training, FDD preparation for all 8 brands, post-acquisition brand integration, and day-to-day franchise management. Before this role, she was a partner at a boutique law firm, mostly advising franchisors and multi-unit franchisees in all matters related to franchising and their day-to-day corporate matters. She's been practicing franchising for 10 years, which encompasses the bulk of her legal career. And her and I are alumni of SMU Law and graduated together. So without further ado, Farheen, take it away. Glad to have you.
Thank you, Fawaz, and thank you for having me for this panel. I just want to make sure everyone can see my screen. It's blue and it says Basics of Franchising and Franchise Agreements up at the top.
Yes, we absolutely can. And another good housekeeping note, as folks have questions, feel free to drop them in the Q&A chat function. I'll be monitoring throughout the session, and I'll interrupt Farheen, and we can talk about some of the questions as we go along.
Perfect. So this could easily be a 4-hour session, but I won't bore you with the details. I'll cover very high-level concepts and high-level, just general things that you should know about franchising if you choose to accept clients either on the franchisor side or on the franchisee side. So to that end, I'll do a quick overview of what franchising is, talk about one of the most important documents in franchising, which is the franchise disclosure document. I'll do a quick overview of franchise agreements and other related agreements, if we have time, we'll take a look at what a franchise agreement looks like, where to find it, that sort of thing. I'll give you some tips on franchisee side advising and franchisor side advising. Okay, so starting from the top, a lot of people, in my experience, even lawyers, especially judges, unfortunately, don't know what franchising is. They have this view of franchising as, hey, there's this big bad corporation up at the top, and they have little franchises that are all controlled by this big corporate entity. That's actually not what franchising is for the bulk of what's happening in the US and overseas. So we're going to talk about what actually is franchising, what franchising is versus licensing, just the general regulatory landscape, because it is heavily regulated on a state and federal level. And the laws are constantly changing, and unfortunately is always impacted by political landscape. Next, we're going to talk a little bit about relationship laws on the state level. We're going to talk about IP as it relates to franchising, and then just general terms in this introduction. So generally, what is franchising? It is a method of expansion and distribution of a business's services and products. So typically, you'll have a franchisor entity at the top that, through the franchise agreement, franchises the right to operate a business under certain trademarks to third-party independent individuals or entities. So you see a few examples of franchises here on the screen, some that are obviously very apparent and some that aren't, like Miss Universe. So all of these franchises operate in a very similar way, but they have some variances, about 5 to 10% on how they actually operate. So what even is a franchise? Just to emphasize the impact that franchising has, it accounts for $3.8 trillion in economic output worldwide. And franchising in the US, especially since I've started practicing in the last 10 years, has literally exploded in popularity. So at some intersection of your corporate or transactions career, you might encounter a franchise, either on a franchisee side or a franchisor on the franchisor side. So really, you have a franchisor up at the top that, like I said, through the franchising model can expand the number of units that they have in various parts of the United States, utilizing the economic resources of third parties. So you have independently owned and operated franchise. That's where that term comes from, because the entity that you're franchising to is independently owned and operated, but the way that they conduct their business is contractually defined in the franchise agreement and as related to licensed intellectual property. Generally, for the franchisor, there's heightened brand awareness, increased value. There's improvement of access for consumers to branded products and services. The one advantage to franchising on the franchisee side is they don't have to start from scratch, and they don't have to worry about some of these very expensive aspects of business building, like dealing with trademarks, marketing, just generally setting up the business in terms of the business know-how, all of those things that typically will take an independent business maybe 5 years to figure out. The franchisor has already figured it out, and they're basically, I don't want to say shortcut, but they're licensing this entire model that they've already tested out to the franchisee. So if you are someone on the franchisee side who is really good at processes, but you don't really want to deal with all of these high-level items, you might be a really good franchisee. And that's really the advantage for the franchisee. And that, like I said, the business model to some extent has been tested, and the franchises typically have a higher chance of success than an independent business. So this is important because on the SBA lending side, they do prefer lending to franchisees who want to open a business through a franchise. And in addition to SBA lending, you are also able to convert 401k funds and roll it over into funding your franchise. So there are different ways to capitalize your franchise, but what's preferred when you're using the SBA and 401k funds is called a ROBS conversion. A franchise is preferred because there is a higher chance of success. So let's talk about what franchising is not. So we hear the word franchises used a lot in sports leagues, and it's a secondary meaning to franchising, but the way that they do it is very different than business franchising that happens and what I'm going to be talking about. Franchising is not an employment relationship, partnership, ownership transfer, or a joint venture. It really is a relationship that's defined, a business relationship that's defined by contract between one entity that's completely separate and unaffiliated with a third party. And the only thing that really connects them is the franchise agreement. One thing that I always try to emphasize is there's no guarantee to success, and it's not a shortcut to the things that really small businesses have to do, which is, they have to have a good business sense, they have to be, have some relationship management skills and be able to utilize the financial aspects of their business in a good way to still maintain a franchise and be successful. This isn't a sort of relationship where the franchisor comes in and runs the business for you. They will license things to you, and you as the franchisee still have to be boots on the ground, be in there every day and get this business up and started. What a franchise is it's not a simple licensing agreement, because in a franchise, the franchisor exercises quite a bit of control in the way that their business operates and in the way that the trademarks and other IP are utilized in the business. So I wanted to highlight this slide, especially because there is some confusion as to what a license agreement is and what a franchising agreement is. So all franchise agreements are license agreements, but not all license agreements are franchise agreements. So the distinctive aspect of franchising is you're not only licensing the IP, but there is a business system and know-how attached to it. There's confidential information. There's usually some sort of product that is, marketed, products and services that are marketed attached to the IP. And in addition to that, there's overarching marketing and other branding and other knowledge that comes with the franchise package that is being constantly monitored and implemented by the franchisor, as opposed to licensing agreements, which, a licensor with a trademark may say, hey, you may use my trademark, put it on your signage and whatever else, but your day-to-day, you can do whatever you want. You can market however you want. You can put this IP on whatever products that you want, etc. So licensing is way less regulated, but the downside is it's up to each state to determine what is licensing and what's franchising. And there are actually some systems that have started as licensing entities that have become accidental franchisors under some certain state laws. So if you have a client who's coming to you and says, no, I don't really want to deal with franchisings, I just want a license, it may actually be harder to pursue a true license in all 50 states, because you might be considered a licensor in Texas, but California may consider you a franchise. And if that happens, you're hit with fines, you're forced to convert to a franchisor entity or not do business in that state. And in addition to that, you have to offer rescission, offer other types of remedies to the franchisees who you've already sold franchises to in that state. So that's just a cautionary thing. There is a difference for our purposes. However, if a client does come to you, I would say really pursue franchising instead of licensing, because that's really what they're wanting to do. They want to have some more control than what they actually have. And in terms of the regulatory aspect, I find that it's actually easier to franchise because at least there's a 50-state structure in place to support franchising, as opposed to licensing, where you're really doing a state-by-state analysis to see if you are a licensor, and you may have to change your business model by state to continue to stay as a licensor. Okay, let's talk about franchise law intersections. So if we're talking about what franchise law is specifically, we're referring to the structure that the FTC has in place state-specific laws that define the relationship between franchisor and franchisee, and then there's generally accepted principles and ways of doing things. Franchising is actually a pretty new concept when compared to other areas of the law. So it started in the late 60s, early 70s, and because of how it has evolved, there was quite a bit of fraud in the 80s and early 90s. That's when the FTC stepped in and said, no, we have to regulate this in some way. And they issued the first franchise rule in the late 90s, and then they amended that rule in 2008. So these are the two structures that you're operating under at the FTC level. And then you have states that in that time period that the FTC was trying to put regulations in place, already had other systems of regulations at the state level. And those never really went away. And the FTC law doesn't really supersede the state law. They kind of work in tandem. And in addition to what the FTC and the guidance that they put forth, actually right now, it's like every 6 months they have new guidance that comes out. It's really changing very quickly. The states themselves have regulators. I'm going to talk about this a little bit later. There are 14 registration states that you have to send your FDE to. There are regulators there that review it, may give feedback. And the states themselves might have additional state level requirements for franchisors in general, and then you specifically. So one example is California. You send your FDE to California. They will ask certain questions. It's just a comment letter process. You go back and forth with the regulator. They may require, financial assurance that includes a bond, or they may ask you to defer fees or any number of things. They may actually ask you to change certain things in your FDD. And there's also, they may also ask you to have a state-specific addendum to your franchise agreement. So they really have their hands all over your documents and your franchise agreements specifically. So that's very specific to franchising, that affects the franchising relationship between the franchisor and the franchisee. And then you have general contract law that applies, right? So that's just common law, contract law, statutory laws, regular dispute resolution, litigation, arbitration, mediation aspects that apply kind of in the contract law area. And then you have the intellectual property law intersection. Really, the franchise agreement at its core is an IP licensing agreement. You license your trademarks, your copyrights, and your patents, and you also license your confidential information. So in that aspect, if you don't have a strong trademark, it's going to be really hard for you to franchise as a franchisor. And I've had clients on the franchisor side who they've had a weak trademark, and it is difficult. I mean, you're constantly fighting with the USPTO. You have constant infringers. I mean, it's just a complete nightmare. So if you are on the franchisor side, a really strong IP attorney, aggressive IP attorney is very important because, and a strong trademark is important because that really is the core. That's the core value that you're licensing through your franchise agreement. And if that's not strong, then you're going to have a difficult time as a franchisor. You're going to be spending a lot of money and resources going down a path to really enforce your IP rights when, if you had chosen a different route with a stronger IP, you may not have to do that.
Farheen, we got one question that came through in the private chat regarding the FTC having jurisdiction or reviewing these franchise agreements. Is that just because it crosses state lines if it's a national franchise?
So the FTC itself does not review your FDDs. The state examiners at certain states do. However, the FTC, I would think, yes, Fawaz, to answer your question, because it crosses state lines, and franchising generally is a federal practice. Like I have practice in all 50 states. So it has general rules that say, if you want to sell a franchise in the United States, you have to follow these rules in order to generate your franchise disclosure document. Some states accept that. They say, hey, if you follow the FTC rule, you don't have to follow any other state rules. Other states say, in addition to you following the FTC rule, you also have to follow our state laws and you have to register our FDD. So really, for most franchisors, that's the extent of the FTC's reach at the franchisor level. However, the FTC can sue franchisors for fraud in egregious situations. So they do have a mechanism for enforcement of the FTC amended rule and other causes of action that the FTC feels like, hey, you've defrauded people. We need to investigate this on a higher level and not just leave the franchisees to, pursue their claims against the franchisor on an individual level. So here's an example. The FTC sues the burger franchise company. I think this was Burger IM. They specifically targeted veterans with false promises and misleading documents. So the FTC came in, they sued them, they essentially shut them down, they fined them. This can happen, but this is not relief for the franchisee or the person, the actual individual who might have been impacted. They have a cause of action at the state level, not at the federal level. So they have to pursue claims under their own state's Deceptive Trade Practices Act. That's typically where the franchising causes of action arise from. But the FTC kind of goes above that and say, we have a franchisor who's an egregiously has violated the FTC amended rule, so we'll pursue that separately from the franchisee. So that's where the FTC comes from in terms of reviewing your documents. They really don't. It's the state examiners that do, but they can pursue fraud claims against a franchisor if it gets bad enough, I guess. Or they have complaints. They do pursue complaints that they receive through their website. Okay, so I'll just quickly talk about the franchise amended rule. This is the last rule that the FTC published, and they've since provided some guidance on how to generate a franchise disclosure document. So I have some examples here. Most franchisors who franchise in the United States are required to generate a franchise disclosure document. There are some franchisors who are big enough that they're exempt, but we're just going to be talking about 99% of the franchisors out there. So this is what an FDD looks like. It's usually a very long document. You're looking at 200 to 500 to 600 page documents. They all vary. But the one thing that would be important is, and I'll talk about this a little bit later, is there is a specific format that they have to follow in order to publish this document. So I'm going to talk about that specifically a little bit later. Okay, the next slide. Okay, I'm going to quickly talk about the state franchise laws. So in addition to the FTC, there are 14 registration states where you actually have to take your FDD and make some sort of registration. Either it's a 2 or 3 page filing, or you have to send your FDD to the state, and there's an examiner there who reviews it, and there's a back and forth process before you actually get registered. So this includes, they have oversight over pre-sale activities. There are also exemptions at that level. And then the states themselves, if it gets egregious enough, can pursue claims against the franchisor. Again, it's the same thing as the FTC, except the states may decide that something you've done in that state is so bad that they're going to pursue a claim against you. So this is where franchisors get caught up. They may be thinking they're a licensor, but they get complaints at the state level. The state securities office is usually the office that oversees franchising. They get enough complaints, they pursue it. They, even if you claim yourself to be a licensor, they may say, no, you're actually a franchisor, and they'll, fine you generally. But again, they don't pursue these claims on behalf of the franchisee. The franchisee itself can pursue its claims independent of the state examiners to get its own relief. But the states may ask you to offer rescission, meaning, basically undo the contract, undo the franchise agreement, and reimburse the franchisee for any financial, spend that they've made. So if they spent like $100,000 on the franchise, you have to offer rescission. You have to reimburse the franchisee for that $100,000 or buy back equipment or whatever the case may be. So all of that is within the state examiners to pursue and issue judgments on. There are also 20 other states. I wouldn't say other, there is some overlap between the registration states and these other states that have relationship laws. So once you've actually entered into the franchise agreement, regardless of what your franchise agreement says, there are laws regarding terminations, renewals, defaults, etc. So one good example is Minnesota. So your franchise agreement can say, hey, you know, franchisee, if you haven't paid your bills, you've been defaulting on not paying your royalties for a certain number of months, you know, 3 defaults of not unpaid royalties, me as a franchisor can terminate you on the 3rd default. Minnesota says, I don't care what your franchise agreement says, you have to provide franchisees a 90 days notice of termination with 60 days to cure. So there are some statutory requirements like that you have to take in consideration. Not necessarily when you're drafting the franchise agreement, but when you go to enforce it, you do have to make sure that your enforcement of the franchise agreement falls within that particular state's relationship laws. Now, how do you know if those relationship laws apply? The franchise has to be in that state, or the franchisee might be domiciled in that state. So sometimes you might even have competing state laws that may apply. So that's the kind of state level analysis that you'll have to do. I'm just going to go over general terms that you need to be aware of. Already referenced the franchisor. That's the actual entity that is franchising, you know, actually issuing the right to use its trademark, service marks, business system in order to a third party in order for it to operate a franchise. The third party that that is obtaining this franchise, we call the franchisee. The franchise disclosure document is often referred to as the FDD, and that is the disclosure document that is generated in response to the FTC amended rule. The franchise agreement is the actual contract between the franchisor and the franchisee for operation of the franchise. In addition to the franchise agreement, you have something that's called an area development agreement, a multi-unit agreement, or a development agreement that gives the franchisee the right to pre-buy territories in order to develop them in the future. So typically how this works is you have the franchise agreement that you sign for 1 unit, and then you have an area development agreement that says, yes, I have the right for the first unit, and then 3 other units that I get to develop in the next 5 years. Intellectual property that we refer to in franchising relates to trademarks, patents, copyrights, and confidential information. In the actual franchising franchise agreement, there may be certain terms. Now, these are just general terms. They may actually be called something different. So this just conceptually, we're going to talk about these. The initial franchise fee. This is the initial fee that the franchisee pays to the franchisor when they purchase the franchise agreement. It's a one-time payment that is paid at signing of the franchise agreement. I've seen this range between $5,000 to $100,000 to $150,000, depending on the franchise that you buy. Next, the royalty fees, marketing fees, renewal fees. These are ongoing fees in the franchise agreement that is typically, aside from the renewal fee, that are monthly. You may have technology fees, and this is, again, it could be, not all franchisors have these fees, but generally just know that there are monthly fees that would need to be paid in most franchise systems. The franchise location. Typically, when in a franchise agreement, a territory is licensed to the franchisee, and it's basically a marketing territory. You have the right to market to these people in this territory, and you have the right to open 1 location, typically. Not always the case. Sometimes there are mobile franchises that don't require a retail center, but a lot of franchises do. And typically in the franchise agreement, the franchisee has to get this retail location approved, and they can only operate at that retail location. That's important because sometimes franchisees think that they can just relocate without approval. That's actually a huge default of the franchise agreement. A franchisor at all times has the right to dictate exactly where you operate, and they have the right to approve that location. Company units are corporate-owned units. So units that are not subject to the franchise agreement that are usually operated by an affiliate of the franchisor. Territories can be called protected areas, marketing areas. They have a wide variety of terms. It's usually the protected geographic area that is provided to the franchisee for marketing purposes. And typically the franchisor does not, again, it's defined by contract, will not sell any portion of that territory to someone else. you get to the renewal stage at the end of, so franchise agreements have a term. It could be 5 years, 10 years, 20 years, just depends on the franchise. And at the end of that term, there are certain renewal rights. So you have to renew your franchise agreement in order to continue to operate that franchise. Okay, I know we've talked about the FDD a little bit, but let's talk about it a little bit more. Where to obtain it, where to find franchise disclosure documents, and generally what to look for when you're conducting due diligence. So an FDD can contain, all kinds of different information, but the information that is in the FDD, at least at a minimum, should comply with the FTC rule. So you get the FDD from the franchisor, its sales team, or from independent brokers. We'll talk about brokers a little bit later, but brokers are third-party external sales organizations that emerging franchisors, startup franchisors will use, so they don't have to maintain an internal sales team. You can find these online. If you go and search for FDDs, there are so many companies that will offer to sell you disclosure documents. Do not ever pay for FDDs and do not allow your clients to pay for FDDs. They are easily obtainable online. California has them on their website, Indiana and Wisconsin. Happy to send these links along. So this is important for due diligence purposes. Also for comparison purposes. So if you have a franchisor who claims to be a franchisor but doesn't have an FDD, or you think, oh my gosh, this FDD is really funky, like it doesn't look like a normal FDD, look them up on these websites, on the California, Indiana, or Wisconsin sites, and do your research. Look into the franchisor because they may have, office actions against them that'll help you as a lawyer, as an advisor, advise your client on whether this franchisor is reputable to go into business with. So these are very good websites to have to do comparison, but also investigate the franchisor. So an FDD is really important because it contains a lot of information about the franchise that is not in the franchise agreement. So this will give you insight into, operational costs, background into the franchisor, and just generally a lot of history. There might be some brands that are exempt and they don't have to issue an FDD. Now, these are really big brands that you would have heard of, like your Burger Kings sometimes. Like McDonald's, I think technically they are exempt, but they choose to have an FDD each year. There might be other brands. If you have never heard of a franchisor brand and they claim to be exempt, chances are that that's probably fraudulent. You probably need to look into that. Most of these exempt brands are so enormous that you would have heard of them just generally as a person existing in the US. Okay, anatomy of an FDD. So every aspect of the FDD is specified on how it should be drafted in the FTC rules. So you can put, together. You can take 3 chicken franchises, for example, and put them side by side and do a really good comparison, because an item 1 will tell you the same information that an item 1 of the other 2 FDDs will tell you. So this is really good because you can put together, do a side by side comparison for initial fees, other fees, or an estimated initial investment, and be able to guide your client into a system that is better suited for them and how much they're capitalized, as opposed to, them just going to pull a franchise because that's just the one that they've heard of. So again, there are 23 promulgated items. This is what a table of contents of a good disclosure document should look like. So all of these documents will have, so here's one I'm going to show you from McDonald's. Looks the same, has the same 23 items. This is another franchise, Famous Dave's, same 23 items and exhibits. So it's really to help a layperson navigate a disclosure document. So it should be easy to read. So another thing to note about the FDD is it should contain all of the contractual agreements that the franchisee would have to sign at the onset of the franchise relationship. So the entire franchise agreement and all attachments should be in there. Development agreements, any other agreements like the general release they would have to sign, and other other companies, other brands may have other documents in there. Like, let's look at McDonald's. They have assignment to an entity agreement, assignment agreements, candidate agreements, other policies. So the table of contents and the attachments will vary greatly by brand, but at a minimum, they'll have the franchise agreement in its entirety in there. The only thing that will be missing is what's specific to the franchisee. So their territory, essentially is the only thing that will vary. So as someone who would be advising a franchisee, look at the FDD. It's going to be a really good source of information. So here are the key items that you should be looking at. Not to say that the other items aren't important, but this really goes to the core and it should be examined pretty carefully. So item 1 is really important. It's the franchisor's background, overview of the franchise opportunity. There's other information in there about, acquisitions made, their current ownership, what the competitor landscape, all of that will be in there. Item 3 and item 4 are important because you need to know if the franchisor, its affiliates, or any of its top people who are operating the franchise are involved in litigation, certain types of litigation, or have filed for a bankruptcy. So if there is a huge litigation list disclosed or bankruptcy disclosed, and they're not a very big franchise, that's a red flag. If it's like McDonald's, I'm not worried about it because they are going to be involved in litigation just by their sheer size. But it is important to know at any stage if the franchisor or any affiliate of the franchisor has been involved in the bankruptcy, because that's going to speak to whether that franchise is going to be able to support the franchisee appropriately. So item 5, 6, 7 all go to affect the franchisee, specifically initial fees, ongoing fees, initial estimated initial investment. This all goes to, the candidate's liquidity, what loan they'll be applying for, and just their general considerations. Item 11 is really important because you need to know how the franchisor will be supporting the franchisee. Item 19 is usually one of the big things that franchisee candidates look at. It's the financial performance of the units that the franchisor decides to disclose in the FDD. Attachments that you're looking at definitely have the audited financials of the franchisor reviewed by a financial advisor. Typically, there's 3 years of audited financials that are required to be disclosed. So you can kind of see the trajectory of the franchisor. And one of the most important things I always ask all candidates to do is there's always, what's required is to have a list of franchisees who are currently franchisees who also have been terminated, not renewed, or otherwise voluntarily left the franchise. So you have a candidate who is looking to consider buying a franchise, they need to be talking to these franchisees. Okay, I'm just going to do very quick remarks on international franchising. Franchising is expanding internationally, but each country has its own framework. So Canada, Australia, they have their own essential, FTC equivalent, their own disclosure documents. So if you are a US attorney, you do need to hire local counsel to advise you appropriately on international franchising. Another big thing that you would have to look out for is trademark registration. So having a strong trademark will help you register your trademark internationally. And just if you have any experience in registering international trademarks, it's a huge pain. So you have to get all of that started ahead of time. But just know that, at least from a franchisor's perspective, it's a whole different beast and requires a lot of resources. And you may also have franchisees internationally who may be wanting to come into the US. Just know that there are other laws that may apply in that situation. Okay, franchise agreements and related agreements. Generally, all you have to know about franchise agreements is that they vary incredibly across all systems, but they do have a lot of core things that are consistent across all franchises, just because if you're franchising, you have to talk about these things. So there's usually a term in the franchise agreement. It could be 5 to 10 years. So this is really important for your clients because they need to know what they're getting themselves into. This isn't like, oh, year 3, I decide I don't want to do this anymore and I can exit. That's typically not the case. You're entering into a business contract that's for an extended period of time. So if you have a client who's like, oh, I don't really know what I want to do, I'll just do a franchise. Look for a franchise that's like a 5-year term versus a 10-year term, or negotiate that in the process of buying that franchise. There's usually a defined territory. There's development procedures. rules around what the franchisee needs to do as they're developing their franchise. There's usually a development schedule. So if they don't follow that schedule, they're in default and their franchise agreement can be terminated. There's usually a section on fees, so the initial fee and ongoing fees. There's a section on operations, both on what the franchisor is contractually agreeing to do and also what the franchisee's obligations are in operating their franchise. There's always some sort of restrictive covenant. This is really important because a non-compete is pretty crucial here. So if a franchisee candidate, if they're a teacher, for example, and they're going into a teaching franchise and you are advising their franchisee candidate, you need to have a carve out to deal with the non-compete and what they can do after they exit the franchise. But just know that non-competes are very common. Obviously, non-disclosures are, non-solicitations are usually pretty common too. Transfer provisions are also common. This is one way that the franchisee can exit the franchise before the end of their term. Now, this is pretty common. We have franchisees who, sell and buy pretty consistently, but you should know what those terms say so that the franchisee has a way to leverage that when the time is right. There's default and termination provisions. If you're advising a franchisee candidate, make sure to review those very, very closely. And the obligations upon termination of the franchise. Again, what does the franchisee have to do when they exit the franchise? And there's usually some sort of dispute resolution provision. Now, arbitrations are very common in franchising, so keep that in mind. Because of how common arbitrations are, there's usually not as much case law in franchisee disputes in some states. So I say that because when you are in arbitration or mediation, you really should find an arbitrator or mediator who is familiar with franchising so they can help you get to a resolution as opposed to someone, an arbitrator or mediator that you have to educate, which really slows things down. Okay. Again, this is just a comparison of how greatly, even the table of contents can vary. But again, there are similarities that you look for. Just if you are a franchisor who's advising a franchise candidate, do review your franchise agreements in its entirety. There might be some contradictions between the franchise agreement and the FDD. So you need to, if there are contradictions, get all of that clarified before your candidate moves forward. Okay, let's quickly talk about multi-unit development agreements. This is just a visual representation of what that looks like. So a development agreement, area development agreement, multi-unit development agreement, that it is a separate agreement than the franchise agreement. So you sign this agreement, the franchisor agrees to give you 2 or 3 or 4 or 10 territories in advance according to a development schedule. And when you get to a point where you're developing each subsequent franchised unit, you have to sign the then current franchise agreement. That's typically how it works, but not always. Just kind of keep all of that in mind. If that's the case, just know that your franchisee might be signing different versions of the franchise agreement for every franchise that they develop. So you, as the franchisee side advisor, may want to negotiate some terms when you are advising on a development agreement. I would also say that some franchise candidates get really excited about a franchise opportunity. I mean, franchise salespeople are very convincing. So they will sign up for like 5 or 10 units and pay this enormous fee upfront. Just as a cautionary tale, unless that franchise client is very well capitalized, chances are that they're not going to be able to fulfill that obligation to develop like 5 to 10 units. So when I was in private practice, I would always really caution my clients against signing a multi-unit agreement, only because sign up for one, see how that goes. And then if you're a good operator, why would a franchisor not sell you more units later on? So that's how I always sold it. I mean, they didn't really listen ever because they were so excited, and they always paid this enormous $200,000 to $300,000 in fees ahead of time, and then weren't able to develop that. And that's just money down the drain. So you're never going to get a refund on fees that you've paid. So just keep that in mind when you're advising clients for multi-unit development agreements. Okay, I'm going to quickly go over franchisee side advising, running out of time. And if you have any questions, please stop me. So this is just a general kind of timeline of what we're looking at in the franchise agreement lifecycle. There's prospect vetting on all that happens at the beginning, where the franchisor and the franchisee candidate kind of talk, and there's a lot of information that the candidate discloses to the franchisor, financials, that sort of thing, to get themselves approved in order to move forward. They'll get disclosed with the FDD, they'll sign the franchise agreement and they pay the fees. Then they'll conduct business under the franchise agreement. And then the end looks like either there's a termination, a transfer, a renewal, or a non-renewal. So this is typically what we're talking about. So this is 5 to 10 years, up to 20 years, like McDonald's has a 20-year contract. So as a franchisee side advisor, which I would think what most of you would probably be doing, is do your research. Just because a franchisee candidate comes to you with one FDD doesn't mean really anything. Like, have them pull other competitors and do a comparison. Now, the FDD is supposed to be written in layman's terms. Like, a normal person should be able to look at pick up an FDD and read through it and understand it. It shouldn't have legalese. So they can do a lot of that on their own. But if they're asking you to do that, then really at a minimum, you should be going on these websites and pulling competitors and seeing if this FDD that you're looking at is outside the norm of what the competitors are doing. Because there could be fees that are like astronomical, especially with like emerging franchisors. Their FDDs can look really crazy, and sometimes the franchisors may use attorneys who aren't franchise lawyers. So, me, like, I can look at an FDD now and say, okay, this person used a really terrible franchise lawyer. I would not advise my client to pursue this relationship with this franchisor. Maybe I would advise them, to go somewhere else, just by how the FDD's drafted, because the franchisor didn't put the resources into hiring a good, reputable franchise lawyer. So when you look at FDDs, you'll kind of pick up on that and be able to advise your client appropriately. It's important for them to have a financial advisor look at item 19, put together their pro forma themselves, and really decide if they have the ability to fulfill the financial obligations of the franchise agreement, and have plan B, plan C in place if something goes wrong. Talk about the personal guarantee and non-compete. The personal guarantee is one of the core things that most franchisors will have a franchisee sign. Now, usually when a franchise agreement is signed, the franchisee signs under an entity, like an LLC, corporation, whatever entity they choose. However, in order to kind of pierce that veil, the franchisor will ask them to sign a personal guarantee that if that guarantees the financial obligations of the franchisee entity. So if there is a default, fees aren't being paid, the franchisor can pursue the owners individually. So you need to protect against that in whatever way. So that could be just estate planning, all of that, succession planning, whatever you'd want to do to help them understand what that is, and that's common. But that doesn't mean that they can't protect against it. So advise them as appropriate on that aspect. Speak to your client on how they're going to fund. That's really, really important. Either it's an SBA, 401k rollover, cash. This will affect how you structure the personal guarantee. You may have to get their financial advisor involved. This is what I always did when I counseled franchisee candidates. I always had a memo where I put all my thoughts down and I gave it to them. And then I would have a phone call and highlight items in the memo. And this really is a risk to protect you against malpractice, because it's a lot. Like, you get on a 1-hour phone call and you're just information dumping to the franchisee. They're not going to remember all of that. So it's important really to verbally say it, but also put it in writing so that your client can sit down and review it, not on the phone call with you, because they have to pay hourly for your time, and usually it's also helpful for them to have something in writing. Next, development considerations. We've already talked about that. And negotiating the franchise agreement. I would say 90% of franchise agreements are not negotiable, but there's always room to negotiate. Some other terms, personal guarantee, maybe the fees, something else that you could kind of get something for your client on, depending on the franchisor. So an emerging franchisor, a startup franchisor, may be more willing to negotiate than a franchisor who's more well established. But that doesn't mean that they won't give you a discount on the initial franchise fees, or whatever the case may be. So I always try to negotiate regardless, because you just never know what you're going to get. If you don't ask for it, you're not going to get it. Again, risk management is really key. Like, yes, franchises are less likely to fail, but that doesn't mean that in this economic climate that they aren't going to fail. So it's just important to have some sort of risk management procedures in place. Next, if you're advising franchisees, know that you'll be pulled in kind of outside of franchising. So you'll be pulled in on the day-to-day corporate matters as well. So employment, vendor contract review, lease review. If you don't have resources for that, then definitely work with other lawyers who can do those things, because it'll be a good opportunity to kind of cross refer clients. Other things that you'll kind of have to advise your clients on, non-obvious items. Don't add owners if they're not approved by the franchisor. Don't sell the business without approval. Don't use the licensed trademarks in a way that's not approved. Most franchise agreements, like I say, have interim and worldwide non-compete. So some franchisees think that, oh, like I have this non-compete, but it's only like for this area. No, it's a worldwide non-compete while you're in term, and then it's a geographically restricted non-compete once you leave the franchise. So again, the non-compete agreement clause will go into all of that. So that's another important thing to advise your clients on. Franchisor side advising, I'm going to just very briefly go over this. I know we only have a few minutes. I would say proceed with caution, because there's so many things that really can bite you, and will be a malpractice issue if you don't know what you're doing on the franchisor side. Remember, it's heavily regulated on the federal and state level. In addition to technical knowledge, experience matters so much. And I will just give a personal example. I mean, I've been in franchising for quite some time, but it's not like I know. I've only been doing this for a few years in comparison to other lawyers who've literally been practicing since the dawn of franchising, like in the late 80s, early 90s. And even with outside counsel that we use, I've seen a huge difference between two firms that we used. One that was, more recent. And yeah, they did the things that I would do, that I had experience doing, but then we switched, firms to a lawyer who had these personal relationships with these state examiners. And let me tell you, those relationships matter so much. I hate to say it, but it does. And we really got the value, even though he charged way more per hour than this other firm. I mean, things were happening faster, things were happening more to our favor. So just know that experience and those relationships really matter. So not to discourage anyone from going into franchisor side franchising, just know that if you're looking to get into it, find a good mentor. That matters so much, because that can really change the trajectory of your franchising career. Next, choose a lane. Typically, franchisor / franchise, you can't like switch between the two. I'm not like 90% of my practice was on the franchisor side. If I ever did advise franchisees, it was really very limited on a case-by-case basis. And I worked for a firm that didn't sue franchisors. That was our thing. Like, we were not going to sue. We were always going to find a non-litigation type resolution to the solutions that franchisees were having. However, there are firms dedicated to franchisee advocates. So, you kind of have to choose. Next, I would say join the International Franchising Association and the ABA Forum on Franchising. They're huge resources in franchising. The IFA especially does a lot of lobbying on behalf of franchising in general. The ABA brings in examiners, the state examiners, to the conferences, which the IFA does one specifically for lawyers in May. The ABA does one in the fall, again, for lawyers specifically. Attend both of them, because you get different information at each, and the law is literally changing like every 6 months, and it's becoming really difficult on the franchisor side to comply and make sure you're doing what you're supposed to. It's not a requirement, but you should have some background in IP law and transactions. One word of caution: don't ever pull FDDs off the shelf and just plug and play, because the FDDs really is such a franchisor specific document that just because you pull one off the shelf that you think is from a big firm, you can just plug and play and it'll be compliant. That is not the case. And I feel like I shouldn't say this, but do not use AI, Westlaw, LexisNexis practice forms. I've looked at these. They're terrible. They're not going to do your client any favors, and they're not reliable at all. So generally, big caution before you decide to do franchisor work. On the franchisor side advising, I can circulate these slides after. Just know that FDD and the franchise agreement has to be customized. The FDD has to be updated every single year if the franchisor wants to sell franchises. This is a huge undertaking. It's expensive. It's expensive to pay franchise lawyers to do this, and they also have to get their audited financials done every single year. That's also expensive, and even more so than paying your franchise lawyers to update your FDD. So if a client is coming to you to franchise, they've got to have money. I mean, they have to be well capitalized to bear the cost of not only the first year of franchising, but every year after that, and their costs only increase year over year. So yeah, keep that in mind, and just know that franchisors are entrepreneurs too. So if you're someone who loves that personality, then you'll do great in franchising. If that is not franchise or entrepreneurs are not people that you enjoy working with, then franchisor side advising is not for you. Just remember, they're kind of building the plane as they're flying it. So you as the advisor, you really have to have a pulse on their business, and you really have to know, like, really understand their business to correctly advise them, understand their personality so you can correctly advise them on what the next steps are, because there might be franchisors who are very risk averse. There's others who are like, I don't care, they're aggressive as, you would want to be. So just know that there are extremes in franchising and dealing with franchisors as entrepreneurs, and just be ready for that. Okay. And that's all I have.
You are amazing, Farheen. That was really a wonderful breakdown of such a complicated topic, and you really captured exactly what we were kind of hoping, which is there's so many angles and flavors and depth to appreciate on everything from the first FTD all the way down to the exhibits that are, making up that agreement. And I certainly learned a nugget or two of new information. Didn't realize everything is prepackaged, ready, and available from day one. And but you have to know what you're looking at. You have to understand the market. You have to look at your resources and bring in the right financial advisors that have the experience to let you know, look, you might have runway for 2 years, but no more. And those are really hard items to grapple with. And you absolutely hit on the good nerve of entrepreneurs are a different beast, an animal, right? They're very risk focused. They're, high risk, high reward people. And as lawyers, we're very risk averse usually. So we absolutely should outline the issues we see, but should walk that line very finely to make sure we're not discouraging them to such a point where we're kind of holding them back from what they're expecting to do, because they're going to leave you and find a different lawyer that's going to help them.
Yep, exactly. So I think when I was in private practice, your job as the advisor is to tell them. They have to at least know. And then they'll make a decision, and then you have to help them execute that decision.
That's right.
Even
that is so right.
The train wreck coming.
Absolutely. Still got to get on the train and build the track as it's happening. Yeah, 100%. 2 questions that popped up here. One is regarding, I think someone made a mention to the movie The Founder, which is that McDonald's movie of how it got started and then he franchised it out. So the question was, is land ownership, does that usually reside with the franchisor or the franchisee, or is the market split on that?
So that is actually not common at all in franchising. So it's very specific to McDonald's that they entered into the real estate market as a way to increase their value. So, and a lot of franchisors don't have the capital to do that, not to pursue the premises ownership. So most of what franchising is right now is that the franchisor that has nothing to do with the premises. It's really their only job is to approve the location, and then the franchisee leases from the landlord, a third-party landlord. There are some franchisees who will buy the premises or they'll build the premises, but that's maybe 1% of franchising. So the real estate really doesn't piece into it's like a completely separate thing. The franchisee deals with that separately with their landlord, and that's a separate relationship.
That completely makes sense. Yeah, and that good to hear that it's more of an outlier in the McDonald's case, because if you watched it, it seemed like that was what every franchisor was getting in
Yeah.
the business to do. Second question, I know we're running right out of time here. On the financing piece, I think they were trying to make the sentiment of what is the bankruptcy overlay with financing, in the sense of, if you as a franchisee
Mhm.
are going through difficulties, do the bankruptcy laws afford you protection to get out of a franchise agreement?
Sure. So the franchise agreement is considered an asset in bankruptcy. Um, so when you will see franchise agreements that say if a franchisee files for bankruptcy, that the franchise agreement terminates, but that's not actually what happens. We do have to, like, the franchisor does have to actively terminate, but they cannot terminate the agreement during the bankruptcy process. So as soon as the franchisee files for bankruptcy, or their owners, whatever the case may be, I mean, I feel like now there's some kind of, we've never seen a bankruptcy that's been filed appropriately, I'll put it that way. Usually it's just the entity or just the owner or some crazy variation of either. So really the franchisors are at the bottom of debtors. Basically, we never get our money. So practically speaking, we don't even file. I know that's not what other franchisors do. They will file claims to get something. But the franchise, it's basically like paused in terms of
Hmm.
franchise. So once a bankruptcy is discharged, then we'll take another look and see, okay, is this person capable of operating, or have they already closed? If they've closed, once the discharge paperwork comes in, we'll terminate and we'll kind of
Oh,
different ways.
yeah, and then that's where that personal guarantee probably kicks into gear as well, perhaps.
Yeah, and if they sign if they file for personal bankruptcy, then we can't really do anything about that either.
True.
So,
Good
uh,
point. Yeah.
yeah, it's tough. It's
It
tough.
is, it is, but nonetheless, yeah, and no one wants to go through that, but I thought that was an interesting question.
Yeah.
Just wanted to make sure everyone got the CLE number, which is 174294017, to note down, and you can self-report it on the State Bar website. Once again, such a pleasure to have you, Farheen, walk us through this complicated area of the law. Really appreciate the fact that you've garnered this expertise, and that you had really words of wisdom for folks that are interested in getting in this area of law, because it clearly is one that is not shrinking but growing, and
It is.
it'd be wonderful to have more of our members and kind of join and take
Yes.
up
Yes.
the mantle with you.
I will say, I want to make a comment. The Dallas Bar actually has a franchise section, so join that if you can. And just, I don't know why Dallas is, kind of one of the key cities that has a lot of franchise lawyers. There are a lot of franchise lawyers who've been doing franchising for many, many years in Dallas. So it is actually a really good city if you want to get into franchising, because not only are there a lot of franchisors here physically, their headquarters are here, but also a lot of great, preeminent minds in franchising are here, been doing it for like 30, 40 years. So.
I can hear the dinner parties now. Yeah, it's got to be pretty scintillating. Well, thank you again, and thank you everyone for attending. Again, we've got a bunch of events coming up towards as we round out the end of the year. Feel free to participate, join, and thank you again, everyone that did today. Appreciate it. Talk to you guys soon.
Bye.